All right, so we're going to go now with part 2 of Mina Crichton versus the New Zealand Police. And we are going to look at the actual evidence, okay? So the actual hearing was, let's see if I can find that for you. Here it is. The fixture reminder, New Zealand Police. This is the case officer's name right here. People in the email is Sean Kinsler, Catherine Bridget. So you can all see that. So the actual hearing was on Wednesday the 30th of October. So it's quite a while ago now. It's January. Okay. So the hearing, this is the court registrar that case managed it, but they had kept moving. They keep changing court registrars, okay? And that's a no-no. Honest to God, that is really serious what everyone's doing. But it's like they're switching. It's all consistent with me being switched by the person that is a substitute and stealing. Okay? It's a clear case of one of those. So this court registrar was the person that was in court when the hearing took place, and the Crown was Kayla Grant, and she was the Crown for New Zealand Police, and the judge was Judge Saxon. Okay, so there's again a new judge. It wasn't the judges that actually case managed the case. So we're going to go straight to the evidence. The Crown was given permission to go first. The court rules and protocol is that when the plaintiff is actually the person that actually lodges the claim, the plaintiff gets overrule over everything, over the defendant, because it's their file. I'm the one who has lodged a complaint against them, so I get first priority because it's my case. But in this case, the defendant has had first priority in everything, and they're doing their own thing according to the law, and that is why I had made submission to the courts that the police had defaulted. They had defaulted in their application. They had also, what was it called? Contempt of court. They lied to the courts. So the Crown was the first person who gave evidence to the court. And the other strange thing, I think it might be something for them to take on board, is that they should actually, it just makes sense that if one person's going to case manage a file, that same person is going to go and represent the case in court. So then nothing backfire on the Crown, if you know what I mean. Because it's just, like somebody else is case managing the cases. I'd think somebody experienced will do the actual court litigating, but they've been using inexperienced people, and then they look really bad in court. But anyway, I didn't feel that this Crown prosecutor wasn't really knowledgeable about the case. I didn't feel she was. But anyway, she made her submission, and it didn't bother me because, at least I get to hear what they have to say first, and then I can cover it when it was my turn. So, but and the real court protocol rules is that I'm supposed to go first, but they went first. Okay, so the Crown made submission. The Crown disputed and tried to convince the courts that I didn't have sufficient evidence. I can't quote what exactly was said. I'm just describing in my own words what was said. So what happened was she had presented, went through her case and her procedure to the courts and what she had put together. And from top of my head, she referred to some case studies, but she didn't really. I didn't feel the police had any substantial grounds or evidence for their case, which was actually I was able to prove. She did say something about the workplace bullying, that they didn't believe that it was a police matter or for the police to intervene. And then they also talked about the delimitation time, like the time frame of everything. Then they talked about the car accident, and the car accident, they felt that they were now doing something about it. Whereas, that's what came out in court. And then their background for their evidence was they were relying on the unlawful strikes that was written by the Ministry of Health, by the judges for that, which I had actually contested, and I did confirm with the courts and the judge in court that I wasn't happy, I didn't agree with them, and that my case is a criminal case, and that as far as I was concerned, that I was going to, take it down to the criminal route. So I made that clear. There's evidence to prove that to the courts. And also the courts also knew that my case is also a public case on social media, because I've had to, for extra intervention, because I've had to, I've been an isolated a victim where I've been secretly exploited for a long time, secretly. So basically I was doing that for not only as an exhibit, because I did submit my YouTube channel and my Facebook page with the courts as an exhibit. So everything I do there is true and correct, because it's mine. It's all about me and my court cases. So I quickly ran the judge through the complaints of the protected disclosure, and what I will do is just go on with the evidence, because the Crown was saying that there was no sufficient evidence to support, my case with the protected disclosure, because they're just facts. It wasn't for them to intervene or for them to take my case, or to investigate and do what I say they should have done, because I've addressed it to them. So this letter here, dated on the 5th of May 2010, was sent to the Commissioner of Police, and here's the address right here. This here's the address I was living at. I'm going to try and be quick with this, because I don't want this on to be too long. So what I wanted to prove to the court, that the police had I had a responsibility to investigate my case, even though I had submitted it in writing. Okay, so I submitted a protected disclosure form, and I wanted them to deal with I wanted them to investigate the workplace bullying, right? And also, so everything in this letter are all facts of my description of what happened while I was working, and according to the laws, I am actually the victim. Okay, but so I've written everything in my own words, and I'm describing these facts as my existence at that point of time. So they are real, and it's true. If you look over here on the protected disclosure, it says right here, Here you go. Serious wrongdoing. If you can read that yourself. It's just save me time. Okay. It's unlawful corruption and all the rest of it. This here is taken out from the actual legislation. So this is where the policies come from for companies and organisations. So they've got to be really careful that they're not making up their own things, and that they're actually in line with the policy. The policies are actually in line with the laws. So what I'm saying is, if you own your own business, you can't make up your own laws. You've got to actually make sure it's in line with the laws, because that is what you'll be judged against. Here it is. I found it. Here's this part here where it gives me permission to submit the protected disclosure to different corporate bodies. And here it is. I chose to go with the New Zealand Police because common sense of the car accident, and they might as well deal with the whole thing. And here it is, the Police Complaints Authority. So this is who I address my letter to. Now go back quickly to this letter. So what I wanted to prove to the courts was the facts actually becoming a reality. Okay, so what I said to the judge was, just from the top of my head, actually I should actually get my diary out and see what I wrote, because I actually scribbled down the things that I wrote, but I'm just doing this from the top of my head. I wanted to focus on the workplace bullying. Now, in this letter, I've described that that I had a reason of belief that my privacy was being seriously invaded. Okay, I had reason of belief that people were just into everything, and I'm naming all the people here: the doctor, even my bank, Westpac, immigration, land transport, inland revenue, telecom, my counsellor, landlords. I'm just naming these people that I felt my privacy was being breached. Okay, now you've got to keep in mind, back in the at this time, my children were young. I was a single mother. So I had to kind of like bring the judge into this generation here back in 2010, get her into the mindset. I told the courts that I was a single mother with 3 young children. Okay, and so I've been independent. I'm an introvert by nature, and I'm not a busybody. Everybody that knows me, I'm very private. I love my privacy, and if you get to know me, then you're quite lucky, because I'm just a private person. I do love people, and I do have a good reputation with mostly good people in my life. I like the people that I have been involved with have all been good people. So I just wanted to get the judge into the mindset that at this time I had 3 young children. Okay, so I've been single and independent most of my life, so I do understand if something's not right, when a breach is easy to detect, or something's not right, and when there's a consistency of something not right, then I just knew I was in very serious trouble, because I felt someone was personally trying to control and manipulate everything that I was doing, which in this case is exactly what's happened. Now we can call it the demolition of a human being, historically. So what happened here is I wanted to focus to the evidence that was exhibited. Okay, so what I was doing is basically bring to life the facts. So I said to the judge that the police could have investigated, in this particular disclosure, the police could have investigated. My driver's license was stolen while I was in there, and there was sufficient evidence to prove that it was stolen. At this point in time, I was a court deputy registrar, and my job involved in me, being in court all the time. And we had a court servicing schedule and a whiteboard, and on that whiteboard, we'll come in and they'll have a schedule of what we're doing for the week. And the schedule is on, everyone gets sent the schedule. That the schedule is sent to everybody. It's sent to other agencies. So everybody knows what somebody's doing that particular day. However, changes do take place where people are away and then you get people to fill in. But my kind of role was, because I was experienced, I was multitask. I didn't really do any one particular thing, but I was mainly taking courts. Whatever courts I was assigned to, that was the court I did. So I was mainly in court, and then if I was in the office, I was doing wash up, clearing my desk, or covering hub desk, covering for other people. That was the kind of role I did. I was the title of the job was court registry officer, but it kept changing. But I'd always had the title of the court deputy registrar from when I first started with my employer when I was in Department of Courts. That just moved. That I never lost that. So the other thing I have found also, I think is really important to mention, is that I've never had a warning with any of my occupations, like even with this job before I was pushed out. I've never had a warning or anything like that. This what happened to me was cybercrime, and I was definitely pushed out. So I was able just to focus on this letter here because I wanted the judge to see what the police was liable and could have actually intervened, even though they said they didn't. It wasn't that they weren't responsible for. They said it was an employment matter. In saying that, the police is actually meant to still investigate. So I was able to focus on the driver's license being stolen. This letter clearly articulates that I'm complaining about people accessing my private everything, my bank accounts, things. They were into everything. And then I was able to bring to light the facts about the car accident that took place on the 18th of March. And then here's the incident number. And then, because the police were saying that they couldn't find the guy, and I don't know, it was just really bad. It just looked like they lied in court. So I did go into the police station and I identified the guy as Jesse Stevenson, and this is the case officer at the time. Now, when I look back at the evidence, I believe that this car accident was actually a hit. Okay? It was definitely a hit. The other thing that I brought to life also in this letter, the police, I tried to follow up about the car accident because I knew the guy should have been charged with careless driving, causing an injury. That's about, I think, 7 years imprisonment. Something like that. That's a serious charge because I ended up getting a neck injury from this car accident. But the police, from my point of view, they let the guy go. Okay? And I can confirm it was a hit. It was somebody must have paid him to do that. Okay? That's why I knew I was in serious trouble. So on this email, I also had names of people, of staff that I felt that could be a witness to the cyberbullying, and staff that I felt that was going along with it, participating with the stalking and everything I was complaining about in court. So now this here falls in my favour, okay, because I was able to prove to the court that in this particular disclosure there were two names that of the staff that was involved in the cyberbullying when I ended up losing my job in unfair dismissal. That was June Tupe and Louise Holloway. But I also had mentioned I knew that there were others, but I just mentioned the ones that I thought that could be the perpetrators or behind the gossiping. The other one was Claire O'Connell, because there's evidence in the file going back to 2009 where I had problems with these 3 court staff, and with the support of the PSA delegate at the time, he advised me what to do, which I did what he told me to do, and sent these letters to these 3 ladies that I worked with. All right, so you can clearly see a big alliance had just grew. It accumulated. See, here's Louise Holloway, and then I just named a lot of people that was a witness to it, but they did nothing. They just left me in there. Okay, so, and I even had supporting emails for the police. You know, you can just read the email, you can tell something's not right, but no one did nothing. They left me in there. These people were like, I was turning my back and they were going, and I was like twinned to them. It was definitely a invasion of privacy and a demolition of a human being at this point in time. There were also letters of complaints that was sent to, here it is, the workplace discrimination. It was sent on the 1st of December 2010, right here, right? And the Northland Regional Manager, I sent the complaint to. She sent me a letter to confirm that she'd received my complaint, and she had CC Tony Fisher, the General Manager. That's the person, and Chris West. They were the ones that was an exhibit. They were the ones that the meeting that is an exhibit for this hearing. But they did receive this letter of confirmation and notification of the letter of complaint, that I had made official complaints about alleged bullying by managers and just a work environment discrimination. That's what it was. This here is dated 1st of December 2010. All that's is an exhibit, along with the recording that is on YouTube and on my Facebook page. Now, the other evidence I feel is really, really, really important is I brought to the judge's attention was what I felt was really important. It's just I can find what I'm looking for. Was that this letter here? Because this is definitely a trafficking in persons case. If you don't know what that is when you're twinned to somebody, like they're glued to you, all right? Which is illegal, but it's been a public project or something, because everybody's been involved, which is really serious and dangerous. But it is called a trafficking in persons. So you see here that I've actually written this letter on the 5th of May 2010. Now, the person who responded to this letter, this is what I brought up in the court, was the police responded on the 6th of May 2010. I brought that up to the judge's attention of the time frame. How is that possible? I just sent the letter and then he responded the next day. How is that possible? And I'd actually sent the letter to what address? Yeah, I sent it to that address in the Auckland City, Wakefield Street. Okay. So he responded and he actually declined it, and then he forwarded it. When I rang up for him, I heard that he left his job immediately. He left suddenly. And he forwarded the application to this person here, Superintendent Bill Cyril, District Commander, Waitemata, and he was the one that responded to my email. And this is the guy's name, and I'll do a separate video clip for this one. This guy's name is Steve Shortland, Assistant Commissioner, and as you can see, he CC'd it to this person here, and he left. When I rang up for him, he left, and I had that conversation from my home landline. Okay, so with that, this guy, WN Cyril, Superintendent, he responded. I won't read it, I'll just go slowly so you can all read it yourself. I'm a bit tired too. So he has declined to actually even investigate the car accident. Alright, so with that, because he declined, going back to this guy, when he declined it, I was really upset, and so I wrote another letter, and this is the other letter that I sent to the same guy. Yeah, I'll just go slow, you guys can just read it. So right here, what you have in front of you is facts, real life, true facts of real life, serious wrongdoing. I'm very consistent sort of a person. It's just, yeah, but anyway, I'll just carry on. But what I did bring up, I felt was important to bring up in court, was by this time, because of, they declined to do anything for me, I was petrified. Okay, now you got to keep in mind that I work for Department of Courts, and I did murder cases, I've done sexual violation cases, I've done serious fraud cases, you name it, I've done it. Okay, so to get something like this is like absolutely serious, and I thought I was going to get killed because I was scared. I was scared out of my wits when they did this to me. I didn't know what to do about it, and except just learn to live with the abuse and the tight surveillance and whatever they want to call it. But they were personally victimizing me. So I brought this up in court and I read it. I said to the judge, because I felt this was important, that it says here, they have worked together to set me up and have gone too far. That is why their plans have gone worse, as they are desperate to destroy me, because they were abusing me, and I was being victimized, I was being twinned, that I was trying to go forward, and felt like I was twinned to the devil. I'll do this and then they'll destroy it, or I'll do this and they'll sabotage it. That is what they're doing also with the relationship scam. Okay, the women that has been used to be the twin, they're the ones being groomed by the public. They're the ones who the public wants to win or whatever it is. But it's absolutely wrong. Okay, so what they're doing is, whoever I'm being twinned to, I'm getting sabotage, and I do this and the other person gets it. I apply for the application, somebody else steals it. So there's definitely clear evidence of money laundering, tax evasion and stuff like that in my case. Okay, so I read this out loud in court, and I read, so what your letter is indicating to me is that unless I am killed or murdered, only then you will consider my application seriously. And unfortunately, that's exactly what I was right. Okay, my facts was right. So when this guy, Cyril here, when he still declined it after writing that letter, I rang him up. From my landline in my home. And I was like, I recall saying to him, do you realize what a protected disclosure is? You have to investigate. And he goes, no. I remember him saying, he was quite outright and says, no, we're not. And it's an employment matter, blah, blah, blah. And then I said, oh, what about the car accident? I said, that was a setup. And he said that I had to actually prove it. How do you prove a setup at that point in time? The thing was, there was sufficient evidence to prove that the guy Had no driver's license on him. The car was deregistered. And not only that, I had actually gone into the Henderson police station and identified the guy as a gang affiliated. And even the lady that was with me at that time, she was I could just look at her face and she just looked concerned. He was only 24 years old, he was Caucasian, and he had a driver. But the police ignored it. But I can confirm now it was actually a hit. And because it was a hit, it was a whiplash to my neck, and there's medical evidence there that it did. I ended up being on ACC for a few months. So that is where the police failed me, right? I did try and follow them up. I can prove that. There were different phone calls. I kept following up. They kept lying to me. They didn't tell me the truth. They kept changing their story. So when people, when a government agency can't get their information correct, that's not right. Something's not right. That's just not right. Okay. So with that, I sent the letter. I wrote a letter to the Independent Police Conduct Authority. Okay, with that, I wrote a letter to them. I won't go over it. I'm going to finish this video clip soon. And the person, see, here's a stamp. And it was dated this. And I sent it to the Independent Police Conduct. This is the other person, the other corporate body that I've sued. And I've basically just sent the protected disclosure to them, and I sent the car accident to them, and they refused to investigate. So here's the letterhead from the New Zealand IPCA, and it stated that. And he's acknowledged, or she, I don't know if it's a she or a he, they've acknowledged receiving it. If you can see there, I won't read it, you can read it yourself. This is a very serious case, okay? And it was this person here, K. Ivan, for Independent Police Conduct. I don't know if it's a male or a female. And that was the end of that for the police. Okay, so in here I had all the evidence for the car accident dated there. I had I'll just go through all this quickly. And from that day forth, the police has not done anything for me. Yeah, they haven't. I don't know what they want to call it, but I'll just carry on. I'm a bit exhausted at the moment, just a bit weird out. So this is the guy who is the driver at this point of time. It was definitely a hit, and the police said that they couldn't find him, but I submitted evidence to the judge. I ran the judge through to the I said to the judge, I did, about the insurance policy. My car was actually insured, but the insurance company, which was Lumley Insurance, did find the guy, did talk to the guy, where the police said they couldn't find the guy. Okay, that is serious. So here, I wrote, his name was Jesse Stevenson, wrote the note in his own writing on the day. He had a passenger driver too. But from my point of view, the police let the guy go. But that was definitely a hit. I'll end it there now because this one's getting too long. And then I'll carry on with the next evidence. Still with the police.